Okay, good afternoon everyone, and a very warm welcome to this ISM Trust webinar about the music education workforce. The ISM Trust is the ISM's sister charity, which offers high quality professional development to everyone working in music. Through the ISM Trust, the ISM gives back to the sector and supports and empowers music professionals to succeed. My name's Ruth McPherson. I'm Head of Charity Development here at the ISM. And in today's session, I'll be joined first by our Chief Executive, Deborah Annette, who will introduce this webinar, and then by our Research Associate, Dr. Jodie Underhill, who will be speaking to you about the ISM's latest report, The Case for Change. Following that, my legal colleagues, ISM Director of Legal Services, Stuart Darke, and Senior Legal Advisor, Nerys Owen, will discuss rates of pay, employment status, contracts, and holiday pay. Now, before we begin, just a few points of housekeeping. During the presentations, please do feel free to ask questions using the Q&A function, and we will do our best to answer these at the end. Please also keep an eye on the chat box, where we'll be dropping in some useful links as we go. If you experience any technical difficulties, please let us know in the chat box, and we'll attempt to resolve these. And if you wish to use them, subtitles are available by enabling them at the bottom of your screen. This webinar is being recorded and it will be available to watch back in a few days' time via the ISM Trust's website at ismtrust.org/webinars. Now, without any further ado, I'm very pleased to hand over to Deborah Annette, the ISM's CEO.
Thank you very much, Ruth. For that introduction. Really good to hear from you about the ISM Trust, which is such an important part of the ISM family. Today we're going to be covering, as Ruth said, The Case for Change, which is a wonderful piece of research carried out by Jodie, our research associate, really looking at the increasing casualisation of so many working in music education and also in academia, and what that means in terms of rights in the workplace. We're also going to be hearing from our two lawyers. In fact, we've got more than two lawyers. It's more like 5 lawyers working with us in connection with all the types of issues that can crop up in the workplace. And I think that's a really important point. One of the great strengths of the ISM is we have an in-house legal team who cover absolutely everything from employment law and all aspects of employment law, from discrimination to breaches of contract, to grievances, to disciplinaries, to something called transfer of undertakings regulations. But also we cover things like publishing contracts, copyright, and absolutely all the aspects of being a musician when you're working for yourself or indeed for somebody else. I think one of the most important things about the work that we're doing at the ISM is we focus on the needs of the individual. And now this is even more important than ever with the cost of living crisis facing so many musicians working in the music sector. And of course, this follows hard on the pandemic and the issues which Brexit has generated. So it's not easy working in the music sector, which is why webinars like this are so important. For ISM members in particular, you have access to our in-house legal team. And please, 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 if you haven't been paid, if there is a fee outstanding, if you're not sure as to whether the way you're being treated in the workplace is right and acceptable, then get in touch with our legal team. They are highly experienced and will be able to help you and make sure that you get the very best advice available. So without more ado, I will introduce Jodie to talk about the case for change. And I think what this shows, the research that Jodie has undertaken, is the interrelationship between research and also the legal team here. The two functions really go hand in hand. We need to know what is going on in the workplace so that we can assist and support those working in the music sector as well as we possibly can. So I'm now going to hand over to Jodie, who will take you through the case for change. Have a good webinar.
Thank you, Deborah. So we published 2 education reports this year, which sit alongside each other. Music, a subject in peril, explored classroom provision and looked at what teachers wanted to see in the refreshed National Plan for Music Education. And The Case for Change, which focuses on the postcode lottery of paying conditions for peripatetic instrumental and vocal teachers, as well as academics working in further and higher education, who have faced an increase in casualisation for more than 20 years. Government policy, changing business models and funding cuts have all contributed to this increase in the casualisation of the music workforce, and these vital members of the music education ecosystem are often being taken for granted, treated differently depending on which part of the country they live and work in, and are subject to weaker terms and conditions as a result of increasing casualisation. The gradual withdrawal of centrally funded provision to both local authority music services and further and higher education institutions has led to a need to cut costs and look for additional income sources. Staff have often borne the brunt of these money-saving measures, with full-time employment and its associated legal rights and entitlements being replaced with less secure contracts and weaker terms and conditions. Currently, each of the devolved nations has a different way of doing things. In Scotland and Northern Ireland, peris employed by local authorities have their own pay scales, which allow for some progression. Local authority Scottish music instructors are also covered by the conditions of service for teachers and associated professionals, which makes provision for a 35-hour working week, including minimum hours for preparation, and a contractual requirement for 35 hours of CPD per year. In their National Plan for Music Education, the Welsh Government have acknowledged that ongoing changes to local authority music services contracts have contributed to an increasing variation in terms and conditions, and have committed to carrying out a review to ensure local authority music teachers are treated equitably. An ISM request for data on the numbers of music education hub staff in England, which the Arts Council have collected since 2019, was denied on the grounds of commercial sensitivity associated with the new investment process for hubs as part of the refreshed national plan. It's therefore not possible to report on how many teachers hubs currently employ and on what types of contracts. However, what is clear is that hundreds of jobs have been lost and many more peripatetic teachers have seen their terms and conditions eroded. The findings of the Case for Change report are drawn from several different sources, including the ISM's annual fees survey and a 2021 survey of peripatetic instrumental and vocal teachers. The combined data represents over 1,200 peripatetic teachers' views and experiences of working in schools across the UK. Interviews were also held with a number of academics working in further and higher education. In our survey of over 350 peripatetic teachers, 41% of respondents described themselves as self-employed, 42% as an employee, and 3% as a worker. Concerningly, 15% were unsure about their employment status. Even when teachers considered themselves self-employed, some hubs and schools were setting the hourly rates or determining who and when they taught. It's not clear if this is merely a misunderstanding of employment law or an attempt to cut costs and avoid employer responsibilities. Our annual fee surveys show that the lowest minimum hourly rate reported by self-employed peris working in schools has fallen by over £10 since 2016 to £16 per hour. However, the highest reported hourly rate has risen by over £20 in the same period. Many peripatetic teachers had not seen an increase in their wages for a number of years, and some were reluctant to charge higher prices, either due to their location, believing that there was a limit to what parents would pay, or circumstances of the children they were teaching. It's often a difficult situation to balance, as increasing fees may lead to a reduction in pupils and, as a result, teachers' overall income. Some schools and music services are charging parents more than teachers are being paid, in some cases almost double. Many teachers also feel that there is no recognition of either their qualifications or experience when it comes to their rates of pay. While the hourly rates for pay for peripatetic teachers may seem much higher than the national minimum or national living wage, many teachers report a large amount of invisible work, which effectively reduces this rate. Our survey data shows that on a typical day, including evenings, almost half of respondents spent between 30 minutes and 1 hour on essential administrative tasks such as answering emails from parents, with just over a quarter of respondents spending more than an hour on these tasks. 93% of respondents were required to write reports as part of their role, but were not necessarily paid for the time to write them. Many teachers are working more hours than they are actually paid for as a result of large gaps in their day due to timetabling restrictions or having to rearrange lessons at short notice. This can also result in a loss of income where lessons are unable to be arranged. The ISM has always maintained that the annual holiday entitlement of peripatetic teachers should be calculated in the same way as for any other worker, by taking a week's pay and multiplying it by 5.6. Yet many employers have been calculating holiday pay based on term time teaching hours only. In November 2021, the Supreme Court heard the landmark case of Harper Trust versus Brazel on holiday pay. ISM member Lesley Brazel brought a formal grievance against her employer in 2013 after they prorated her holiday pay to term time only, as she didn't teach during school holidays. The Supreme Court agreed with the ISM and dismissed the Harper Trust appeal on the 20th of July this year. Our survey data found that only 4% of respondents were receiving 5.6 weeks holiday pay a year, not prorated. Where peripatetic teachers were enrolled in a workplace pension, this was not necessarily the teacher's pension scheme, which many teachers were eligible for when employed full or part-time through music services. After the government increased employer contributions to the TPS by 43% in 2019, hundreds of independent schools left the scheme. State schools were not affected in the same way as the increase was covered by the government. Changes to the TPS and the subsequent withdrawal by some employers has affected both the terms and conditions of pay of some peripatetic teachers. Pension contributions are also affected if teachers are paid hourly rather than salaried and for fewer than 52 weeks of the year. Our annual fee survey shows that the number of self-employed peripatetic teachers paying for room hire has gradually increased by 5.5% since 2018. However, the number of self-employed peripatetic teachers paying admin fees has fallen 0.8% since 2019. Some schools are charging room hire as they believe this helps to prove the self-employed status of the teachers. A number of peripatetic teachers spoke of their feelings of being undervalued, not only through their pay and conditions, but the way they were treated in schools. There was also a perceived lack of understanding from school staff about the nature of peripatetic teaching in multiple schools and one-way flexibility. Our peripatetic survey data shows that 72% of respondents were on a 0 hours contract. This often resulted in a great deal of uncertainty, particularly at the start of each academic year, as well as financial insecurity. This has huge implications for housing, childcare, and being able to pay bills. Even when teachers were salaried, there was still a feeling of insecurity. Some peripatetic teachers were also concerned about the implications of illness or falling out of favour and their hours being reduced or them being replaced. Others were willing to accept fewer hours in the hope that pupil numbers would increase, as some work was better than no work. Fluctuations in pupil numbers during the school year added to the feeling of insecurity, and many peripatetic teachers were at a disadvantage by teaching pupils in exam years when they left for study leave. Income could also be affected by the amount of notice given by parents when pupils stopped lessons and to what extent these minimum periods were enforced. It wasn't always clear how some schools were applying them, particularly when pupils moved from one site to another, for example, moving from an independent school's junior school to their senior school. COVID also saw some schools and music services waive their notice periods without thought for how this might affect the teacher's income. In addition to the casualisation of the instrumental and vocal teacher workforce, there's been increasing casualisation within further and higher education. We spoke to a number of academics working within higher education music departments where several recurring themes emerged. The first was difficulty in visiting staff getting paid, either as freelancers receiving the payment or as university staff seeking to provide payment. Frequently, financial systems do not appear to be set up to pay for visiting self-employed staff, resulting in multiple emails back and forth, complex procedures for probing identity, status, and bank details, and long waits for payment. In one case, a visiting freelancer had still not been paid by a university nearly 18 months after the event. Others had simply written off some payments that had taken too long. Insecure contracts, poor treatment of staff, and issues with funding were also highlighted. Some staff spoke of a move to more casual contracts as a result of budget constraints. One spoke of an incredibly gradual culture of cutbacks and a cull of full-time staff, halving the numbers in one academic year. Another mentioned the erosion of one-to-one tuition over the past 25 years. There was feeling overall that higher education was now being driven by money over everything else. The focus was less on student experience and more on universities as commercial businesses with the students as customers. Hourly paid lecturers were often being asked to do work associated with senior lecturer roles, and others were afraid to complain as their roles were vulnerable and they were frightened of losing their employment. There was also a lack of recognition in some cases of long periods of service and no attempt to move staff from hourly paid roles to more secure types of contract. In some cases, academics were applying for grants for long-term research projects, despite only being employed on short fixed-term contracts. The Case for Change presents a series of recommendations and suggestions for best practice, which organisations can adopt to support their staff. Freelancers and the self-employed face a range of challenges that are not experienced by salaried staff, and organisations should acknowledge this and ensure that they are not subject to unfair working practices or non-consensual self-employment. More equitable contractual practices are needed, and contractual stability should be a core organisational objective. Organisations should commit to a level of pay that reflects staff qualifications and experience and which allows for progression. Staff should be fully supported to access CPD regularly and given opportunities for reducing professional isolation. Peripatetic teachers and academic staff are a vital part of the wider music education ecosystem and contribute enormously to the pipeline of creative talent in our world-renowned music industry, and yet they are being taken for granted. We need a qualified, secure, and fully supported workforce, properly remunerated for their skills, experience, and expertise.
Thanks very much, Jodie. That was a really insightful look at the report's findings there. And as you say, very wide-reaching impact of that report as well. If you have any questions on the report, please put them in the Q&A box and Jodie will try and answer these towards the end of today's session. And now I'm pleased to hand straight over to Stuart and Nerys to present on how you can protect yourself. Thank you.
Hello there. Can you see me? Hi, yeah, I'm Nerys, so I'm a senior legal advisor at the ISM. I'm going to talk to you today about employment status. Now, why am I going to do that? Why does it matter? Well, employment status matters because it's the gateway to all the statutory rights at work that you may or may not be entitled to, such as paid holiday, which we're going to hear from a bit more about from Stuart shortly. But also very fundamental things like protection from discrimination, sexual harassment, the ability to get reasonable adjustments at work if you're disabled. Now, genuinely self-employed VMTs have no statutory employment rights. This is a key thing to understand. Why is that? Well, it's because you're not a worker and you're not an employee. Instead, you are running your own business. So what you have instead are only the contractual rights that you have agreed with your own client or customer, the parent. Now, it's important to recognise, and we recognise, that lots of our ISM members prefer to be self-employed. They would rather run their own business contracting with parents at arm's length. They like the control and the freedom that this brings. But equally, many of the VMTs who approach us in the legal team for advice bring with them supposedly self-employed contracts, which when you talk about it properly and you scratch the surface, it becomes quickly obvious that really they are workers and sometimes employees, giving them statutory rights. So that's why it matters. But when does employment status matter? Well, in our experience in the legal team, it tends to matter at an individual level when things go wrong. For example, because you suffer discrimination at work, or maybe you develop a disability, or perhaps the contract is ended unfairly with no notice. So in practice, members often have no choice but to put up with unacceptable terms like the lack of holiday pay, for example, because people need the work and frankly, because they're in such an insecure position. But when things do go wrong, then if you're an ISM member, you should come to us in the legal team, and you should always remember that employment tribunal deadlines are very short, so it's important not to delay. So then if we look so that's a sort of individual level, but we can also think about this a bit more broadly, about how these employment status issues apply in music education, and the sort of impact they have, building on what Jodie's just said in her presentation. So we see two main focuses of concern here, and you can see them coming out of the practical consequences that Jodie's outlined. And the first is 0-hour contracting. This is where you have a contract with no guaranteed hours of pay. Your wages, your hours go up and down depending on your pupil numbers. So this is an arrangement which is lawful, and it is now commonplace. It is now endemic, but it is highly insecure, as we've heard. But then we have false self-employment. Now, false self-employment is unlawful. This is where an organisation pretends you are self-employed for the purpose of your employment rights, when that is not the case. Now, both arrangements in practical terms on a sector level make it much harder for other businesses to compete, obviously, because fair and stable terms and conditions cost more. So they drive this race to the bottom. And where are we seeing these problems? Well, actually, we're seeing them everywhere, certainly in England. So we've heard the statistic from Jodie about how many VMTs perceive themselves to be on a 0-hour contract. I think it was an extraordinary figure, 72%. As far as false self-employment is concerned, well, speaking anecdotally as a member of the legal team, I have to say we find this all the time. It's in high street music schools where you might go to do evening or Saturday work, but it's also in state and independent schools. It's even in large publicly funded music services, and it's in universities, and it's in conservatoires. So I'm going to look now in my next slide at the law. What does the law tell us about employment status, and how can it help us? So it is complicated, but there are three basic categories. The first one is an employee, the best one, if you like, someone who has an employment contract, whether or not it is written down. Clearly, it's much better if it is written down, so everybody knows where they stand. Employees have the most rights, although, as we've seen, you can have a 0-hour employment contract, but it's still better than being falsely self-employed, as we will see. Now, the second class of person, if you like, is someone who is genuinely self-employed. So what does this actually mean? It is someone who is running their own teaching business. They're operating at arm's length, they're on school premises, they're contracting with their own clients and customers, the parents, they're setting their own hourly rate. Okay, self-employed VMTs will typically have to meet some basic criteria in order to be able to access the school premises and the pupils. So it's common sense, really. The obvious one is you have to have an enhanced DBS certificate, you have to do your annual safeguarding training, you're probably going to have to sign up to data protection policies and so on. But the basic contracting arrangements with the parents should be up to the self-employed VMT. Why is that? Because they are running their own business. And then in the middle, we have this odd category of worker. Now, what is that? It is someone who is not an employee, but who agrees to work personally for an organisation like a school that is not their own client and customer. In other words, what I mean by that is they are not genuinely self-employed in their relationship with the school, and instead they are essentially controlled by the school. And I'm going to come on to that in a little bit more detail in the next couple of slides. But typically a worker contracts on a casual basis as required, and this is what differentiates you from an employee, where the arrangement is much more regular. So we can look at this in a little bit more detail, drill into this a bit, but first I want to talk about a really important Supreme Court case that if you follow this sort of area, you may already be familiar with the Uber taxi drivers, Uber against Aslam. Absolutely groundbreaking. There aren't many cases that come along that make such a huge difference. This is a case about employment status and false self-employment. And what the Supreme Court said was that when it comes to deciding who gets to decide the sorts of, who gets to access the sorts of statutory worker rights we are talking about here, employment tribunals have to ignore the employer's written contract documents. They have to pretend they're not there. They can rip up this section of the document. Instead, what they have to do is look at what is actually happening day to day between the parties. Now, that is a radical stance, isn't it? And why did they say that? Well, because they recognize that this documentation has been written and crafted by the employer, and then it's given to you on a take it or leave it basis, and you get no or minimal opportunity to make any changes, no opportunity in the vast majority of cases. And what the Supreme Court said is it simply cannot be up to employers to decide who gets to access these sorts of basic statutory worker rights. And we're talking about things like the right to protection from sexual harassment at work, for example, by crafting their documents in such a way as to make it look as if you are self-employed when you are not. So now, instead, what we have to do is look at how the relationship actually works in reality. And when you think about it, any written contract terms that are in that document that you've been given, even if you've signed it, if they say things like, I accept that I am self-employed and I have no employment rights, all those things are irrelevant. They have no legal effect. So that's a very powerful stance, a very powerful backdrop to what we're talking about. So let's then think about, am I an employee? So the question is, do you have an employment contract? And remember, to repeat myself, what matters is not what the document calls itself or what job title you're given, for example, freelance music practitioner or self-employed consultant, whatever it is. What matters instead is your relationship with the organisation as it works day to day in reality. So an employee is somebody who has to work under the employer's control during agreed working hours. They're following reasonable instructions in return for an agreed wage, traditionally the work wage bargain it's called, and if they don't do that, they can be disciplined or dismissed. Now, the more control there is over you, practically speaking, the more likely you are to be an employee. And one key hallmark of being an employee is that you accept some control outside your working hours. I put a couple of examples up there on the slide, but basically the more restrictions that are imposed on you in your supposedly self-employed written contract document, the more likely you are to be an employee or a worker and not a self-employed person. It always depends on your individual circumstances, but if this is you and you find yourself in this sort of situation and you're an ISM member, come and see us. Now, let's just pursue this theme a little bit further. So on this slide, what I've done is I've set out some of the aspects of your day-to-day relationship with the organisation that can point towards you being an employee or a worker, even if, as I say, you're described in the contract document as a self-employed consultant or a freelance music practitioner or whatever it happens to be. So firstly, your contract is with the school, not the parents in a school setting, or it's with the music service, not the schools in a music service setting. The school or the music service fixes your hourly rate. A real self-employed business would set their own hourly rate. They would look at what the market can bear and they would decide what they want to charge. A school or a music service controls your invoicing. Now, a self-employed person controls their own invoicing, as we know. Here's a good one. You're treated as a member of staff to the outside world. So, for example, you're promoted on the school or the music services website as, say, one of our team of instrumental teachers. The school controls the way you work. So there's a whole range of ways in which this could be: your hours, where you work, timetable, how much notice you get of any changes, what syllabus you have to teach, whether you have to write reports, how many reports you have to write, what form they have to take, and so on, whether your lessons are reserved, what you can wear, and so on. So these are all the sorts of factors that suggest that after all, you may not actually be a genuinely self-employed person from an employment rights perspective, regardless of what the contract says. It always depends on individual circumstances. So as I say, if you've got a problem, and you're an ISM member, get in touch. And a key point I want to make here is about tax, because it's so confusing. This is something that confuses a lot of people in this context. So worker status is about rights at work. It is not about tax. HMRC doesn't recognise worker status. So for tax purposes, there are only two categories. Either you are an employee, in which case you should be on the payroll, or you're self-employed, in which case you're responsible for your own tax and national insurance. So you can be generally self-employed for the purposes of tax, and at the same time be a worker for the purposes of employment rights, such as holiday pay, for example, that Stuart's going to come on to in a minute. Pausing there, in this other slide, what I've done is I've set out some of the main rights that all workers have. Now, I'm not going to go through them. I've put them there so that they're in the presentation. Just let's look at the top one: paid holiday, 5.6 weeks a year, which is the one that Stuart's going to come on to. Some of the other ones I have referred to already. There are some very important ones in there. For example, the itemised pay slip, the Equality Act protections we've already highlighted. But what is important to notice, though, is what is not in this list. What is not in this list is any right to any form of job security. So workers may have statutory rights while they are working, but they have no protection from unfair dismissal, they have no right to notice, they have no redundancy rights. Who has those rights? Well, only employees have those rights. So employees have all the basic worker rights along with job security. Let's not get too excited about it, but they have the best job security that is available in the UK when it comes to employment rights. So you're talking about notice, protection from unfair dismissal. One of the key things for VMTs is that employees have much better protection if you're the target of a safeguarding allegation, for example, under keeping children safe. They also have the sorts of parental rights like maternity leave and the ability to at least try to get your job back at the end of your maternity leave. Only employees have those rights. But let's come on, my final slide, to what is missing from all these lists of statutory rights. What is there not? There is no statutory right to fair pay, and there is no statutory right to fair hours. As long as your average pay is better than the national minimum wage, which is £9.50 for over 23s, your hours, your hourly rate, the work you have to do for that hour, all depends on what is notionally agreed, and I say notionally because, as we know, we have no bargaining power in this relationship, in your employment contract. And that is why zero-hour contracts are not unlawful. And what does that translate into in practical terms? What it means now, speaking from our experience in the legal team, is that apart from those VMTs with school teachers paying conditions, for everybody else, it is a bit of a Wild West out there. Even in music services, there is no consistency in approach to terms and conditions. So we see school teachers paying conditions, but we also see zero-hour contracting, and we even see false self-employment. So just to tie this back into Jodie's presentation, this is why policy change is needed in England, the sort of policy change we're starting to see in Wales and Scotland. So that's the end of what I want to say on employment status and how it impacts on your rights such as they are. And now Stuart's going to talk to us about holiday pay. Thank you, Stuart.
Thanks, Nerys. Good afternoon, everyone. I'm Stuart Darke. I'm the Director of Legal Services here at the ISM. And as Nerys said, I'm going to talk to you about holiday pay and particularly about how to calculate it. I'm also going to touch on the Brazel and Harper Trust judgment, as Jodie talked about a little bit as well, and what that means for visiting music teachers and other part-year workers. Obviously, from the outset, well, not obviously, but from the outset, as Nerys has said, I'm going to be clear that the holiday pay entitlement, which is a universal right enshrined in the working time regulations, applies only to those categorised as workers. And this obviously includes employees, but doesn't extend to those who are genuinely self-employed. Genuinely self-employed people are not covered by the working time regulations and therefore don't have that right to paid holiday. But all workers and employees have a legal right to 5.6 weeks of paid holiday in a year. Now, it's expressed in weeks and not in days. So that means that it might be slightly different for different people. So a full-time worker who works all year round would get 28 days, a minimum of 28 days of holiday. But a part-time worker who works all year round would get less than 28 days, but it would reflect their working pattern. So if you worked 0.5, half of the working time, then you'd actually get 14 days of paid holiday, but this still amounts to 5.6 weeks in your working pattern. Now, the definition of workers, it includes agency workers. So if you're a supply teacher, you're entitled to holiday pay. It includes workers with irregular hours, so term time only employees, and workers and employees with 0-hour contracts. So all of those people have that right to holiday and paid holiday in the working year. Now, the 5.6 weeks can include bank holidays. And of course, employers can give more than 5.6 weeks of paid holiday. Also, employers can specify when you take your leave. So we know that VMTs are normally told that they have to take their leave during school closure periods, and that is allowable. But it is important to check any contractual documentation that you might have for your work, because that will give you information about holiday pay, how it's calculated, and what you're entitled to. So at first glance, when you look at the working time regulations, the calculation appears simple to work out how holiday pay should be calculated. You merely determine a week's pay and then multiply it by 5.6 weeks to work out the annual entitlement. Now, you have to work out a week's pay, and that's where potential complications come into play when we consider different working patterns. Now, again, those workers who have fixed hours and fixed pay, whether full-time or part-time, a week's pay is easier to work out, as it's just what you are paid in a week. But it's more difficult when looking at workers with no fixed hours or pay, such as VMTs. Now, you have to work out what you have to do for those workers with no fixed hours or pay is you have to work out the average over 52 weeks. But you don't include any weeks where you receive no pay. Now, I'm going to come back to this, so don't worry if it's not wholly clear at this point. But the way of calculating average pay is what the law says, the 52 weeks average. And the fact that some employees and workers on permanent contracts are only contracted to work in term time is not relevant. So it doesn't matter that people might be only a term time worker. And this is what the Brazel case was about. Now, as Jodie said, Lesley Brazel is a music teacher. She's a music teacher at Bedford Girls' School, which is run by the Harper Trust. She only works during term time, but she has a permanent contract with her employer. Her hours and pay can vary depending on the number of pupils that she is teaching. So she's a part-year worker on a 0 hours contract. Now, in 2013, the school changed the method that it used to calculate holiday pay. At the time, the legislation required average pay to be worked out over a 12-week period rather than a 52-week period, but the method was the same. That is, it excluded weeks where there was no pay. Now, the school moved to a method which was included in ACAS guidance for casual workers. Now, that guidance has now been withdrawn as a result, and was in fact withdrawn in 2019 as a result of Mrs. Brazel's case. And what the ACAS guidance said was that employers could use a pro-rata method to calculate holiday pay. And they used a formula of 12.07% to work out holiday pay. So they would take what you were paid, what a worker was paid, you'd multiply that by 12.07%, and that would give you the holiday pay. Now, this formula was used as it represented the proportion that 5.6 weeks of annual leave bore to the total working year. So the working year is the whole year, that's 52 weeks, and you take off the annual leave entitlement, 5.6 weeks. And so you get 46.4 weeks. Now, 5.6 weeks is 12.07% of 46.4 weeks. And that's how they got to using that formula. But that's not how the legislation was worded, and not how I described it in the previous slide. And this resulted in a reduction in the holiday pay that Mrs. Brazel received. So she received less under this pro-rata method than under the correct calculation, because it didn't take into effect, it didn't take into account the fact that she was working only during term time. Now, Mrs. Brazel approached the ISA legal team and we helped her to raise her case with her employer. They refused to return to the correct method of calculating holiday pay, and the matter went through the court system and took a considerable period to work its way through the court system. But the ISM supported Mrs. Brazel, our member, all the way through the process, all the way up to the Supreme Court. And we used the legal expenses insurance, which is purchased on behalf of ISM members. Now, Supreme Court heard the case in November 2021. And as Jodie said, judgment was given in July 2022. Now, the decision was that the legislation did not allow for a pro-rata method to be used to calculate holiday pay, and that employers should use the method set out in the legislation, and they should use that to calculate holiday pay for part-year workers who had permanent contracts. So just returning to this idea about how do you calculate, how do you work out what a week's pay is? Well, what's included? Well, you should include any regular paid work on top of your normal teaching. So, for example, this could be regular paid commitments such as ensembles or training days that you're required to attend. Now, in order to calculate the average pay, you have to look, as I said, at 52 weeks of pay. That's not just going back 52 weeks, but going back 52 weeks of being paid. This means you only include weeks where you have been paid, and you disregard any weeks where you have not been paid. Once you've gone back 52 weeks of pay, then you work out the average by dividing the total amount of pay by 52. Now, just a quick note here as well. It's slightly different if you're starting or leaving a job, and that's normally where you don't have enough weeks. And then you'd work out the average in the normal way, but excluding any zero pay weeks. Now, for VMTs, we know that that means going back to to pay in previous teaching years in order to calculate that average. So, for example, let's consider a teacher who teaches term time only in a school. They work and are paid for 35 weeks of the year. You don't just divide the pay in those weeks by 52 to work out the average pay. You'll need to go back into the previous year to get 17 weeks where there was pay. So this might mean going back over 2 terms in the previous year. Once you've got 52 weeks of pay, then you total it all up and then divide it by 52. And that's how you work out what a week's pay is for the purposes of holiday pay. Now, what's clear from the Brazel judgment is that schools should no longer be using the pro-rata method of calculation. So moving on, thinking about what schools should be doing and how this might impact on visiting music teachers. Well, as I've said, schools should stop using the pro-rata method to calculate holiday pay. And this is, the Supreme Court was absolutely clear in their judgment that this should not be used. So schools need to start using the correct method of calculation as it's set out in the working time regulations. Now, an interesting point here is, when will schools pay holiday pay given holiday has to be taken during school closure periods? Now, actually, in the Brazel case, she was paid 3 equal payments for holiday pay. So the employer took 5.6 weeks, divided it by 3, giving 1.87 weeks for each payment. Now, we've also been made aware of a school who is proposing to pay 1 week of holiday pay for the Christmas or during the Christmas closure period, 1 week of holiday pay during the Easter closure, and then pay the other 3.6 weeks in the summer closure. Now, what's crucial here is that they pay 5.6 weeks of holiday pay and use the correct method to calculate a week's pay whenever they pay that holiday pay. Now, obviously, what you need to do, and we tend to advise people, is check your pay slips. Whenever you're paid holiday pay, it should be separated out on your pay slip. It should be clear. Now, you can't have rolled up holiday pay. So if you're a worker or an employee, then it can't be included in your hourly rate. It's got to be separated. It needs to be spelled out by your employer so you can go and check it. Also, of course, now we're hearing about what's happening with the employer changing the way that they calculate holiday period as they move away from using the pro-rata method. Now, an employer should come and consult with affected members of staff. And we're also seeing some schools trying to make other changes at the same time, such as moving to paying each month for actual work done rather than smoothing out pay. So just be careful about what is being changed. And if you're an ISM member, come and take some advice from us. There's also a question of back pay if the employer has been calculating holiday pay incorrectly. Now, back pay claims where holiday pay has been paid, albeit incorrectly, are limited to 2 years. So any discussion about changing the method of calculation should also include talks about 2 years worth of back pay. Be careful though, as once a correction is made to holiday pay and once the employer is paying it correctly, then a worker or an employee only has 3 months from the last incorrect payment to make a claim for holiday pay. So don't delay in contacting us. Don't delay if you're an ISM member in contacting us if you're not being offered 2 years worth of back pay. Now, if you've been completely denied holiday pay through sham self-employment, as Nerys was describing, then case law suggests that you're able to claim all the holiday pay which should have been payable. So it's important point to make is for you to keep records. So keep your pay slips, look back over what you've been paid and what you're able to prove. As Nerys said, problems do arise, and Nerys and I have talked in generic terms about the law and how it operates. But often individual circumstances can differ. Contracts can be different. And so it's important if you have a problem and you're an ISM member that you get in touch with the legal team. Deadlines for employment cases are short, so don't delay in getting advice and trying to sort out an issue. And this relates to other matters as well. As Deborah said right at the start of this session, even with things like unpaid fees, if you've got an unpaid fee and you're an ISM member, it's better to come and get some advice rather than miss a deadline or rather than delay. Now, the email for ISM members is up on the slide. It's legal@ism.org, and non-members can use the details on the slide to join. And remember that part of ISM membership is access to the ISM legal team and to the legal expenses insurance, which gives members support when taking claims in areas such as employment, unpaid fees, and personal injury. And so we've come to the end of Nerys and I's session as well. And I think Ruth's going to come back online and my colleagues, and we're going to answer any questions that there might be.
Brilliant. Thank you so much, Nerys and Stuart. That was fantastic. There's lots to take away there. And particularly the Brazel judgment is really fascinating and incredible that the case went all the way to the Supreme Court. So we have had some questions in the Q&A box, and we've also had some questions that were submitted in advance. So we're going to try and get through as many of those as possible now, but do continue putting your questions in the Q&A box. If we can't get through them all just now, we will try and follow up with you afterwards. So firstly, a question for Jodie, a political question to start. Is the ISM concerned about the reported plans for a dilution of workplace rights under Liz Truss's government?
Absolutely. To just kind of clarify, these are retained EU laws that relate to holiday pay, equal pay, limits on working hours and parental leave. And actually this kind of bonfire of workers' rights that have been promised seem to be in direct opposition of what's been promised politically, particularly in the Conservative manifesto in 2019, which promised a new employment bill. There's been a flurry of activity really since 2016 and an interest in kind of gig economy and employment law. Various reviews like the Taylor Review into fair working practices that made over 50 recommendations, but only 7 have been adopted. And between 2020 and 2022, ministers have promised 20 times in Parliament that they would deliver the employment bill, which has been mentioned in various Queen's speeches since 2019, and that's yet to be forthcoming. So it's very concerning. that these rights could be under further attack when they've been promised previously to be protected by the employment bill.
Thank you. That does sound concerning. We've also had a question on the difference between the situation for music educators in England and the devolved nations. So someone's asked whether the ISM thinks that the upcoming Welsh review of music services will help the situation for the music education workforce.
I would say it's a little unclear at the moment. It is kind of mentioned in the Welsh National Plan. It's described as a local authority, a review into local authority hosted music services. But it doesn't have much detail at the moment. It's due to start in the autumn of 2023 and last a whole year into the summer of 2024. But we don't have the details yet as to exactly what that review will entail. I think from my relationship with the civil servants in Wales, I would say they have a greater understanding of the issues that instrumental and vocal teachers face, and possibly also a greater desire to address them.
Okay, thank you. Now we've had lots of questions on pay, holiday pay and also sick pay. So firstly, perhaps this is one for Stuart, and it's quite a long one. So Stuart, I don't know if you saw this in the Q&A, but somebody has asked, my employer has changed my pay schedule in light of this update. Presumably that means Brazel, from a monthly fee, which was calculated across the year, to monthly pay linked to a monthly timesheet, meaning I won't get paid much in September, January and in August, just a lump sum for holiday pay. Should I challenge this?
Well, it goes to something I did say in the presentation as well about we are seeing where members have come to us and talking to us about changes that are being proposed by employers. We are seeing employers doing other things, and this is one thing we have seen from ISM members telling us that schools are looking to change the I don't know, I wouldn't describe it as frequency of pay, but the method of calculating pay. So some schools would have smoothed out the payments so that people got the same every month, maybe for a term, and they're looking to that timesheet. What I would say is it may well depend on the contractual position as well, about what happened beforehand. And I think we probably want to see people's contracts and give them some individual advice about what it means and what they're potentially agreeing to. So I would probably say if you're an ISM member and you've asked that question, come and take some advice from us. We'll give you some individually tailored advice about your circumstances, having looked at your contract and what's going on. Certainly, I wouldn't say don't agree to anything without coming and taking some advice first as well.
Great, thank you, Stuart. And perhaps this one's for Nerys. Regarding sick pay, somebody's asked, are freelance instrumental teachers eligible for sick pay?
Well, this sort of goes, doesn't it, to some of the issues that I was just discussing. I mean, one of the funny things about sick pay, statutory sick pay, is actually it's quite an old right, and it's linked to the payroll. So you have to be an employed earner on the payroll in order to be able to get SSP. I mean, the other thing about SSP is it's extraordinarily ungenerous. It's one of the most ungenerous rights of, of a suite of incredibly ungenerous rights. It's right there at the bottom. So you don't get anything for the first 3 days. And what you do get, I think, is £99 a week, I think. But anyway, if you genuinely are a self-employed person, and on the basis that I was discussing in my seminar, then no, you have no rights to sick pay because you have no statutory employment-related rights at all. But with sick pay in particular, that's an employee's right, very obviously, and so you've got your layer, you've got your SSP, but you've also, there's, SSP is so bad that what you really want is contractual sick pay linked to your actual wages, and that's something which is to be negotiated, and it's something that our members do tend to lose out on actually, because they find themselves having to, yes, they can be off sick, but they have to make up the session, so effectively they're not even getting SSP. So if it's an issue for you, again, it's one of these things, come and raise it specifically in relation to your particular issue. If you want to have a chat about it, that's absolutely fine.
Great, thank you, Nerys. We've also had quite a few questions about employment. So one of them was, what percentage of us, I think that means music teachers, are workers and not genuine self-employed? I don't know, Jodie, is that one for you, or Nerys?
Yeah, I mean, I think it's almost impossible to say, really. In our survey, only 3% identified as a worker, but obviously that's self-reporting. And in terms of the UK as a whole, because the nations all have different ways of doing things, particularly in England, as I said, we couldn't access the hub data to find out what the situation was with contracts. But obviously, if you're a self-employed teacher working in the independent sector, for example, there's no way to collect that data. There's no requirement to report those members of staff anywhere. So it's almost impossible to know even how many instrumental and vocal teachers there are across the UK, let alone what their status is.
It's impossible to say because it's such a nebulous concept. I mean, you know, what you're talking about effectively, as I said in my presentation, in general, you're talking about false self-employment. You're talking about people who are, you know, people are pretending, schools are pretending, or music services are pretending they're self-employed when they're not. Now, if they're not employees, if they're working on a more casual basis, they may be workers. But that's why I said in my presentation, you know, anecdotally based on the issues that come through the door to us, there's obviously no knowing, because how can you survey for something like that? Because nobody really knows, you know, and it's very much, you know, you face your particular individual problem. And it's, yeah, I mean, you know, that's what I was trying to get across. There is an individual issue here. There's also, you know, a sector level issue. And the problem is for the individual that it's very, very hard to challenge this, you know, until something goes wrong. You know, it's very, very difficult to challenge this during the course of your relationship. So there's no knowing, basically, is the answer.
So a bit of a depressing answer, but thank you both. This is a really interesting question. Someone has asked, why are schools allowed to make teachers self-employed so that they don't have to pay holiday pay and pension contributions? Nerys, perhaps that's one for you.
Well, that's an interesting question, isn't it? I mean, say, why are they allowed? I mean, why are they doing that? Because employer national insurance is obviously a big cost. Pension contributions are also a big cost. So if you've got a group of employed people, employed VMTs, and you are looking to restructure your workforce in some other way, you could have a genuine redundancy situation. You know, you could consult with that group of VMTs, and you could decide, well, actually, that I'm better off having self-employed people. I'm genuinely real self-employed people doing the work instead. And then, so you'd have to have a proper redundancy consultation, and you've got more than 20 VMTs, you know, you have to have a full-blown consultation. If you don't, you're liable for a protective award. You have to pay notice, you have to pay redundancy pay. But then what's interesting at the end of it, what do you do at the end of it? So if you then offer all the same people the same job, but suddenly they're self-employed, what's happened there? I'm sorry, you know, the odds are it may well be false self-employment. And that's not just, is it, a question of statutory employment rights, but surely in some of these situations, it might be a question mark for HMRC, because who's lost out in this situation? Obviously, it's the 15% employers' national insurance contributions, you know, not to mention the pension that now has to be funded by the state because it's not being funded by the school, and so on and so forth. So it's a complicated question. How can it happen? Well, it does happen because as I said, it can be a legitimate redundancy situation. But what happens at the end when people are dismissed, you know, what happens is the question, isn't it? What happens to those jobs? And I wonder, you know, if VMTs go back and take those jobs, are they really self-employed? Don't know. Well, not unless they're setting their own hourly rate and doing business directly with the parents.
Okay, thank you. I think we're going to have to wrap it up there because we've come to time, but this has been a really interesting conversation, and I think it's something that's happening on both a micro and a macro level, clearly. And I think on a micro level, I would say if you have any questions, please do email membership@ism.org if we haven't answered your question and you'd like to ask one. And if you're an ISM member, you can contact our legal team at legal@ism.org, and we can try and help you in any way we can. On a macro level, I know the ISM will continue to campaign on these issues, and Jodie, thank you very much for your fantastic report that you and the team have put together, and it is something that we will continue to work on. I'd also like to say many thanks to Deborah, to Jodie, Stuart and to Nerys for presenting today, and to everyone for joining us. I hope you found the session informative. So hopefully there's a link in the chat with some more information on how our legal team can help you if you're a member, and the recording will also be available shortly on our website at ismtrust.org/webinars. Our website also has a range of webinars and seminars that are available to view back on demand, along with resources to support you, and many of these are available for free. And if you want to find out about upcoming ISM events and resources, as well as news, you can sign up to our monthly newsletter, which we'll pop a link to in the chat as well. So finally, I just want to say thank you again for watching, and we hope to see you at another ISM Trust event soon. Goodbye.
Cheerio.